complaint. I have not heard anything from the state.
Tell the victim what to do, Nathan. I'm not going to say, can you please block your number so we can't call you?
The least restrictive means, Judge. Strict scrutiny dealing with constitutional rights.
No other way to prevent him from making phone calls. I have acquiesced to you guys before and I've admonished him before. Please don't. We put you in SEG last time. You were there a month. You came here begging and pleading. I'm not going to do it. I'm not going to do it. And now we have 300 phone calls. So I don't know what else to do. But now back into SEG.
I'm going to sprinkle the word allegedly to the phone calls because it's the kind of thing where records would exist that have not been provided to the defense by the state.
Do you have the records?
Well, I have them. I just have to get the do the forms or get them up with the forms. Yeah.
Okay, so let's set up for a formal hearing because I don't want. You're right. I don't want to give you state the benefit of the doubt without him actually or Anna actually seeing it and seeing that the phone calls were actually made. So let's set up for a formal hearing. How soon can you get him the evidence?
I'm trying to think of the last time that I got killed. It could be tomorrow, it'll be a few days. So, I don't know if we want to set it off next Monday or something like that. I think I should have it by then. This was just the point of that. Actually, connected with spend those places.
And if we could keep him in normal population so that we could visit him, as does his felony counsel, and they could
Wiggins, I'm going to have you sign an affidavit today promising me you're not going to reach out to the complaining witness in this case by any means. If you do, I can have a contempt hearing, and every single time it's punishable by up to 6 months in jail and a $500 fine per the advice of your lawyer. Because he thinks this is the correct avenue instead of AgSeg. Do you understand?
No.
Don't contact the complaining witness. We are going on the record. If you want to talk, please go outside.
Judge,
Hold on. So we're on the record. It cause number 253-4377, 2505-146. I think that's all we have here, right?
Yes.
Yes. Okay, so guys, for the record, please announce yourselves. State.
Anna Eady, EADY, for Mr. Wiggins.
Nathaniel Munier spelled Munier, also for the defense.
So hold on, before you get into anything, state. You wanted to bring something to the court's attention.
Yes, Judge. So we had received a call that Mr. Wiggins was in violation of the protective order that was in this VPO, and that he was reaching out to the complainant witness in this case. We have checked the jail calls. Those jail calls show that since March 24th, which is, of course, after the October VPO, since just March 24th, we have 293 calls made to the complainant's phone number. Just yesterday, we had, I believe, 28 calls to that number.
So in one day, you're saying he made how many calls?
So yesterday, he attempted 28 calls to the complainant's phone.
So, Judge, I'm going to preface this conversation with, Miss Edie texted me about 10 minutes ago, so I came up on short notice on this. But my understanding is that there's no longer a protective order in effect because it's been long enough that the protective order.
There's an order for him not to have any contact with her.
Are those part of his bond conditions?
Yes.
My client's not on bond.
Well, he is not supposed to have any contact with her whatsoever.
I understand, Judge, but the way that this court and other courts in the county have structured those conditions have been bond conditions, which my client is not on a bond. He is in custody. He has not broken.
I have ordered him, even though he's in custody, not to call her.
I understand, Judge. Assuming that he had violated some form of a court order that is not a bond condition, I believe the appropriate remedy would be contempt, and which would be a separate criminal proceeding. At the same time, for Ms. Edie talking to me today, it sounds like that the court was going to order AgSeg in the jail, so the formal.
The only way that we can revoke phone privileges on someone is AgSeg.
Yes, Judge. My issue with that is it's a hammer when a scalpel is needed. So while I understand that the district attorney's office has alleged that my client is called a victim in this case, there's no protective order in place. The bond conditions are not in effect because he's not on bond. Thus, no crime has taken place. And third to that, Judge, if he's to move to AGSEG, he would not be able to make any phone calls, not just to the victim, but anyone, including counsel, which while we are here on a misdemeanor, he is in custody on a felony and relatively serious felonies. And not being able
okay, I understand your plight.
Yes, Judge.
But there are other remedies for you to be able to communicate. Letters, in person. But the only way for me to be able to ensure that the complaining witness is not called is to put him in segregation. That's the only way.
Judge, the problem is nobody would be able to call, including our office as well as his felony attorneys. Letters through the jail are notoriously slow. A letter to my mother who lives in the same city takes 4 days. Add in the jail, you're taking over
And
a
I'm
week.
willing to put him on the docket one time a week so you guys can have contact.
Which the problem is, Judge, we would no longer be able to have any form of private contact, and that would only take care of the misdemeanor and not the felony. And not to be impolite, Judge, him having conversations with us are saying, hey, what's going on with the felony? And any jail visits that take place in AGSEG are actually recorded. They're notified by counsel going through the door that those calls are being recorded.
I don't have any other option to not prevent
Judge,
phone calls.
This would violate my client's 5th, 6th, 8th, and 14th off the top of my head constitutional rights. Right, self-incrimination because every conversation is going to be monitored going in and out of the jail because they're going to be recorded via jail visits. He will no longer be able to have private visitation inside the courthouse.
You can pull them out. You can have private visitation in the rooms there.
It's not about me, Judge. It's about felony court. It's a serious issue. But that's the
Why are you worried about felony court?
Because that's why he's in, Judge.
That's also in because of ours. Our bonds are at $60,000.
I understand, Judge, but the reason that this is taking as long as it is and it's been taken as serious as it is because he's in custody on a felony. And this court making him to where he cannot participate fully with counsel is...
There are other means for you guys to participate, but I've ordered you not to have contact with her. You've called her now over 300 times. I don't understand why you guys aren't filing additional charges anyways.
Sorry, Judge, I missed the last statement.
The only way that I can prevent him from making 300 phone calls is to put him in another wing.
I was going to talk with the DA, and obviously if my client's making these calls, and that's an if, he's dialing a single number, the jail's numbers can be easily blocked. I've done it on my cell phone numerous times when I've changed cell phones. Over the weekend, last weekend, I had 15 jail calls from one client. And as annoying as that is, it's very easy to block it on your cell phone. And I assume the victim could do the same.
This is the turning point of the entire hearing.
Don't use
Up
anyone
until
else.
now, both sides have been
contact the
arguing about
complaining
how to
witness.
enforce the court's order,
Don't use
not
anyone
necessarily whether
else's
contact should happen.
number to
The
contact the
prosecution says
complaining
the defendant
witness.
made hundreds of calls despite repeated warnings. The defense isn't exactly defending the calls themselves.
Rephrase what he just said.
Instead,
that means calls going
they're
through third
challenging
parties.
whether
So
the
if you
judge
call
has the
mom and
legal
have mom
authority
call
to
her,
respond
that's
in
against
this
the rules.
particular
If
way.
you call mom and have mom forward
That's a
the call,
critical
that's against the
distinction.
rules. I said
In
it.
court,
I said
it's
it.
often not just about what happened.
Okay.
It's about whether the law allows a specific remedy. The defense is essentially saying, if our
This
client
is the
violated
affidavit
an
that you're
order,
going to
there are
sign
legal
promising me you're
procedures
not
for
going to
that.
contact her.
You
and-
can't skip
or
straight to the
complaining
harshest
witness in
consequence.
any of my
On the
misdemeanor
other
cases.
hand, the judge is looking at
Do you
this from a
understand?
practical standpoint. From his
Okay,
perspective,
so you want to set it for
if
Monday?
someone has allegedly ignored
Okay.
previous warnings and the calls keep coming, the court has an obligation to protect the complaining witness.
But just get
That's
it
the
as soon as you
tension you're
can,
seeing
get it to
unfold.
them.
Constitutional
Have a hearing
rights versus
on Monday
public
to
safety,
see whether
legal
he's
procedure
actually
versus
making phone
immediate
calls that
prevention.
We ordered him not to.
And here's where this gets especially interesting.
This is you swearing
The
that you will
defense
not
even
make these
suggests
calls.
that blocking the
Let it
jail
be
calls
clear
could be a less
that it
restrictive
truly
solution
have
instead of
no
placing the defendant into
least
administrative
restrictive
segregation.
means
That's a creative
than
argument
to
because courts generally prefer the least restrictive option when constitutional rights may be affected.
deny his
But the
ability to
judge
make
isn't
phone calls to
convinced
the
that
complaining witness. There
technology
really
alone can
is
stop
no
someone
less
who has
restrictive
allegedly
means.
found
Judge, my
otherwise
understanding is that